56, the motion is agreed to. We move to part 4, which is the debate on clauses 70 and 71. The question is that part 4 stand part. Andrew Little.
Thank you, Mr Chairman. Mr Chairman, this is a very brief part, but it actually is very powerful in its impact. And I think it's very important to draw the House's attention to just what is going on here. This severely limits parties to family court proceedings access to legal aid. And it's interesting to note, sir, the advice that was received, the officials' advice that was received about this matter, and the advice from the external reference group that talked about this as well. By denying legal aid to parties who are required to participate in the mandatory family dispute resolution process, it effectively means that the parties, those at least who cannot afford their own counsel, will be unrepresented. They will be unrepresented. I won't come to some issues about legal aid shortly, but it's interesting, Mr Chairman, to see what the advice, the regulatory impact statement said about this and the impact of this particular provision, the expectation of it. And it is that by making legal aid unavailable to this sort of process, then it will reduce the cost of legal aid for care of children cases, which is the bulk of them, the bulk of which legal aid is granted for, but to the tune of $41.3 million over 3 years, over $10 million a year that will be saved in legal aid. And I'm sure there'll be some cabinet ministers would rub their hands together with glee, thinking they can save that sort of money. But the cost, as we would expect, will be picked up, is likely to be picked up elsewhere. And it's interesting to see what the external reference group, the expert reference group, said about this, about the lack of legal representation, both for the partners who are in dispute and any children involved in it. And they talk about, in the family court cases involving high stress to parties, and that for a wide variety of reasons parties struggle to advocate for themselves, which is why they typically and traditionally have access to legal counsel throughout the process. Not the small amount of advice they can get access to before the mandatory family dispute resolution process, but actually having advice throughout the process, because when you are participating in, whether it's a mediation type or facilitated type process or informal court proceedings, you are taking part in something that will have significant legal implications for you and, if you've got children, for your children for some time to come. And so people rightly approach it cautiously, and because they want advice on the implications for them and their children. And the external reference group, the expert reference group, talked about the impact of this measure, which effectively denies legal advice to people when they need it most. And that is that there will be other direct and indirect costs to the public purse, likely an additional administrative resource required, because listen, if people are not sure about the agreements they're entering into or the points they're being asked to agree to, they can't get advice. Their best option is to kick it to the court and hope the court can fix it up and sort it out for themselves. There is going to be a greater call on the facilitators who are expected to be engaged in this process to start providing advice. They will be clear they can't provide legal advice, but they'll be prevailed upon to do so, and that's going to bog things down as well. But there's something else going on, Mr Chairman, that I think is even more insidious, and that is what is happening to legal aid. Earlier this year, this House passed amendments to the Legal Services legislation, to the Legal Assistance Act, that allowed the Legal Services Commissioner to impose interest on legal aid debt. It hasn't happened until now, and indeed in many cases where legal aid has been given, at least in civil matters, there's been a charge or a caveat put on people's real property. But now the Legal Services Commissioner has the power to impose interest on it. And the House might like to know that the Legal Services Commissioner has been busily going around imposing interest on legal aid debt, particularly historical legal aid debt, in just the last couple of weeks. Letters have gone out to a large number of people telling them that they now owe money on their legal aid debt. People who have had a legal aid debt, in some cases for 12 years, and never received a single piece of correspondence about it, and now being told they have to pay interest on it. Well, Mr. Chairman?
Andrew Little.
Mr. Chairman, this will continue to be an issue under this legislation because if people cannot get advice in this mandatory process and they kick it off to have a judge sort it out, that is the only basis on which they will get access to legal advice. And they will have an incentive to do it, but they will now be subject to a further burden. And many people who have an existing legal aid debt are now being chased for it. And what is worse, they are being charged the usurious and extortionate rate of 8%. 8% interest on a grant of assistance to impecunious people, poor people, who need legal assistance at the time of great distress and difficulty for them. And this government now comes after them and says, you're going to pay a rate of interest that is several times the rate of inflation, that is more than you would pay on a first mortgage rate, that is more than the 90-day bill rate. This is a way that the government, through the Ministry of Justice, can fleece poor people and make money. That's what it's about. And it will happen to people under this bill, if this bill is passed in this form, where legal aid will be required because more people will seek to have their family disputes kicked off into a court process, and they will need, because that's the only way they're going to get access to legal advice to understand the implication of the agreement they're being asked to agree to. And the Minister might like to answer just what her expectations are of the demand for legal aid and the cost to people now with this dreadful and insidious interest rate that's now being imposed on it. Because there is no reassurance in this bill that people are going to be treated fairly and properly for it. These changes, the limiting of access to legal assistance and legal aid for this important process, a very important event in someone's life, is, I think, an absolute shocker. And, Mr. Chairman, the expert advisory group went on to talk about depriving legal counsel, legal advice to children tied up in these matters, because that's what this bill does as well. Children won't even be represented in the family dispute resolution process. Previously, they would be, and there would be assistance for them to do that. There will be no legal aid for children to get access to advice on the implications of any agreement for them. And that is a more horrifying prospect. It is, as I've already said in this House, in my view, a breach of the United Nations Convention on the Rights of the Child, and it goes against the advice of the expert reference group, a very high-powered, highly qualified, highly experienced expert reference group, who also said and has lamented the bill for denying legal advice to children tied up in these events. And they think that it is going to put children at risk because the court won't have independent information on the views of the child, and they point out that it is usually only after a lawyer has been appointed for a child that underlying issues that affect the children are the first time that they are notified to the court, because the truth is the parents who are trying to do the best they can in their situation are focused on getting their situation sorted, their emotions stabilised, and of course they will want the best for their children or child, but their view about what that is will differ with the other parent and indeed possibly from the children themselves. And so, sir, it is a bad day for this House if we go ahead and pass this provision that denies legal aid, under clause 71 of this bill, denies legal aid to not only to the parents of children going through a dissolution in this context, but also denies legal aid to children themselves. This is a bad day for this House, but we should be considering legislation like this. That is why we're opposed to it, and we're opposed to what is happening with legal aid generally.
Mr. Chairman.
Honourable Phil Goff.
Mr. Chairman, part 4 amendments to the Legal Services Act.